Empty Set gave me this wall of text. He believes that my analysis of the elements of the crime that Mr. Warden was recently convicted of is somehow flawed. I could skip through all of this just to get to the meaty points, but I'm sure I'd be accused of missing something so important and critical. So I'm going to go over it, and you get to go along for the ride with me. Enjoy. You glossed right over the most important issue, just like the court did. Oh, do tell. The entire point of stop and ID laws is to make give me your name a lawful order. That's genius. In states without such laws, give me your name isn't a lawful order. Again, that's genius. For example, California has no law requiring people to identify themselves when detained. That's an amazing example of something I didn't need an example of. This is retarded. I don't know why I'm reading this. Excuse me, this is uninformed and misinformed. I don't know why I'm reading this. A cop can stomp his feet all he wants and scream at you, give me your name, until he is blue in the face. But in California, that isn't a lawful order, and I like to say the same thing twice and be redundant. Never start a paragraph with the word and. You shouldn't start a sentence with the word and, let alone a paragraph. And actually, the law in Nevada is particularly on point because this situation with Mr. Warden happened in Nevada. Oh, no, it didn't. That's too bad. Nevada has a law which states a person shall identify themselves when lawfully detained. NRS 171.123, which doesn't say the quoted text there, but it says something reasonably similar to it, so I won't fault you too much. But when a person declines to identify themselves, they're not charged with failure to ID. Oh, do tell. Could it be obstruction? Could it? Could it? I can't wait to find out. You're so smart. They are charged with NRS 199.280, resisting a public officer. Oh my, this is so pertinent. I can't wait to hear what you have to say next. But again, the point is that declining to identify oneself in Nevada is only resisting during lawful detention. Right. So you're going to cite something that says that the stop that Mr. Warden has is an unlawful detention. No, he links to Hibble. Whoopee. Okay. All right. We're not arguing the validity of the stop and identify the statute. So why are you linking me the stop and identify statute? Is your argument that the stop and identify statute for Louisiana, CCRP 215.1, are you saying that that's unconstitutional? No, you're not. No. Are you saying that the resisting and obstructing RS 14-14:108, are you saying that is unconstitutional? No. You have no idea what you're talking about. Just for the record, you're way off base. You're in left field right now, but whatever. I'm going to keep reading it because I don't want anybody to think I'm leaving something important out. We now know the man arrested on Grass Valley Road is, okay, it's a quote from Hibble, whatever, Larry Dudley Hibble. Hibble was charged with willfully resisting, delaying, or obstructing a public officer and discharging or attempting to discharge any legal duty of his office in violation of Nevada Rev Stat 199.280/2003. The government reasoned that Hibble had obstructed the officer in carrying out his duties under 171.123, a Nevada statute that defines the legal rights and duties of a police officer in the context of an investigative stop. Now, are we going to talk about investigative stops? Are we going to talk about Terry v. Ohio? You see, I have it up here. It's important. Are we going to talk about that? And it's the same in Louisiana. Give me your name is only a lawful order during a lawful detention in Louisiana. All right, so we're going to talk about lawful detentions in Louisiana. Awesome. About damn time. This wasn't a lawful detention. Congratulations. You're almost to the point. Are we going to talk about the point now? And from the sound of it, at least the way David described it, the court did all it could to avoid discussing whether it was a lawful detention. I don't know what you think you're proving there, but you're not proving anything. Either it was or it wasn't a lawful detention. David's subjective view about what he thinks the court was or wasn't doing is immaterial. David has no understanding of the law, as is evidenced by his motion to dismiss, where he tried to use an expert citing facts that weren't in evidence, giving legal conclusions that are inadmissible. David has no idea what he's doing. Why do I care how David describes what he thinks the judge is doing? It sounds like the judge believes that give me your name is a lawful order regardless of the circumstances, whether or not a person is being lawful detained. Is that what it sounds like? Well, if that's what it sounds like, well, poof, I guess case closed. I mean, if that's what it sounds like from your subjective interpretation of what you think David said or meant about David's subjective interpretation, whether he was lying or not about it, we don't know, about what he thinks the court was doing. I mean, who can argue with that? That's not the way things work. You know what? What you just described isn't the way things work. Lawful detention would be Terry v. Ohio, not Hibble. Hibble's irrelevant to your argument. In Hibble, the court determined it was a lawful detention. The court determined that Hibble was stopped lawfully. Your task is determining whether or not David's stop was lawful. And all I got from you is that wasn't a lawful detention. That is a legal conclusion. You've provided no facts to support that legal conclusion. You've provided no law to support that legal conclusion. I will point you at Terry v. Ohio, where in Terry v. Ohio, he saw one of the men leave the other and walk southwest on Huron Road past some stores. The man paused for a moment and looked in a store window, then walked on a short distance, turned around, and walked back toward the corner, pausing once again to look in the same store window. He rejoined his companion at the corner, and the two conferred briefly. Then the second man went through the same series of motions, strolling down Huron Road, looking in the same window, walking on a short distance, turning back, peering in the store window again, and returning to confer with the first man on the corner. The two men repeated this ritual alternately between 5 and 6 times apiece, in all roughly a dozen trips, none of which was a crime. At one point, while the two men were standing together on the corner, a third man approached them and engaged them briefly in conversation. This man then left the two others and walked west on Euclid Avenue. Also, not a crime. Chilton and Terry resumed their measured pacing, peering and conferring. After this had gone on for 10 to 12 minutes, the two men walked off together, heading west on Euclid Avenue, following the path taken earlier by the third man. No crime has been committed. He feared they may have a gun. Thus, he followed them and saw them stop in front of Zucker's store to talk to the same man who conferred with them earlier. Deciding the situation was right for direct action, Officer McFadden approached the three men, identified himself as a police officer, asked for the names, etc., etc. So you explain to me, empty zero set, if that series of actions in Terry v. Ohio gave the officer probable cause to believe that crime was afoot, and he gave objective facts that supported his suspicion, explain to me in detail, using roughly the same number of words, exactly why you think Mr. Ward's detention was unlawful. I challenge you to do that. I don't think you can. I don't think you will. But I challenge you to do that. Now, to turn this crap video into something reasonable, I'm going to continue on ever so slightly. Going back to Terry v. Ohio, you may realize at some point, you may not, I don't know how alert you are, but now that I'm going to mention it, you'll probably realize it, that Terry in Terry v. Ohio was not charged with, nor was he arrested for armed robbery. That's the crime that Officer McFadden thought he was going to commit. Whoever thought of that? Who noticed that? Raise your hand. Put your hand back down. I'm joking. You can leave your hand up. Why are you raising your hand, dude? I can't see you. You're retarded. Anyway, what Terry was charged with is unlawful possession of a firearm or something like that. Because he patted him down, he found the gun, etc., etc. They were formally charged with carrying concealed weapons. Oh my. That is not armed robbery, you may notice. Or you may not, depending on your general level of awareness. I'm sure if you're a sovereign citizen, you probably won't notice anything. So, in Freeman's world, that means that he was unlawfully detained, unlawfully arrested, since he wasn't charged with what he was detained for or something. But pause and consider that. Pause and consider that. When you're thinking about things that are constitutional or unconstitutional in regards to the Fourth Amendment searches and seizures, think about the very, very low standard presented in Terry v. Ohio. Mull it over. Because I don't think it wasn't a lawful detention. I think it was a lawful detention. I think that Rufus didn't have probable cause for the arrest, but I think Rufus did have reasonable suspicion for a detention. And you're free to disagree, but if you're going to disagree, don't be an empty set. Support your claim. Give me the facts. Give me the pertinent law supporting the pertinent facts. Or give me the pertinent law that, combined with the pertinent facts, will support your conclusion. That's what I meant to say. Thanks for watching. Have a great night.